Y'all may be seated. Yes, sir.
And I'm moving for a mistrial. We raised a objection to lack of foundation. The case is Monroe v. State, 340, Georgia Appeal, 373, 2017. It provides that the Honorable Court has wide latitude to admit demonstrative evidence, and the burden is on the party offering demonstrative evidence to lay a proper foundation establishing a similarity of circumstances and conditions. Although the conditions of the demonstration need not be identical to the event at issue, they must be so nearly the same in substantial particulars as to afford a fair comparison in respect to the particular issue in which the demonstrative evidence is directed. Further,
All right, pause right here. This is a big legal moment. The defense is arguing that the state introduced a demonstrative exhibit without laying proper foundation. In plain English, they're saying the jury saw something that wasn't proven to be fair or accurate first. And once the jury sees it, you can't unring that bell. Question for you, should that alone justify mistrial, or is this just aggressive lawyering?
To or demonstrative evidence, like any evidence offered at trial, should be excluded if its probative value and the case goes on. But we emphasize the language that we stated. Your Honor, we raised a lack of foundation objection. Your Honor alleviated the state of their burden to prove any type of substantiality between the tests that Mr. Agent Grove, is that correct? Engineer Grove conducted and allowed the state to introduce this demonstrative. Once the bill is wrong with the jury, it cannot be wrong. As we've said throughout this trial, Mr. Faust's defense has been handcuffed. The state has had free reign. It's to the point where our objections aren't even acknowledged. So, Your Honor, based on Mr. Faust's due process rights, violation of Mr. Faust's due process rights, and the entry of this exhibit, we would ask that the Honorable Court grant our motion for mistrial.
Thank you. Mr. Yalman, any response?
Your Honor, the foundation for the admission of the exhibit was laid. We haven't gotten to any questions as far as what testing was done by Mr. Grove who went through his qualifications. One, the motion was untimely, even fast forwarding for the purposes of, and I would just note for the record, the only thing that's been displayed to the jury is a picture of the exterior of 160 Farm Drive. So, but just fast forwarding a little bit, Your Honor, Mr. Grove received information, tested certain things that were part of the theory as far as how the fire began in this case, and those are contained in the report. I would also note for the record that Mr. Cruz had an opportunity to review this PowerPoint last night in its entirety. He did not raise any kind of issue with the court prior to bringing the jury. It's certainly, one, it's not even improper, but two...
Notice the language here. Due process violation. That's not casual wording. Defense counsel is accusing the court of fundamentally tipping the scales. That's courtroom nuclear language. Judges take that personally, and you'll see why in a second.
It's not grounds for...
Mr. Cruz, you got it. Mr. Cruz, I'm going to let you respond because it's your motion, but you need to let Mr. Yalman finish his statements. Go ahead, sir.
I said that the evidence is not improper. You're making no personal attack on Mr. Cruz, but additionally, there are no grounds whatsoever for this trial based on this, which is properly authenticated, admitted evidence as a demonstrative age.
Thank you. Mr. Cruz, anything further?
Absolutely. The Honorable Court, at the conclusion of court, allowed us the opportunity to view this demonstration. The state, in multiple arguments, has insinuated that I have to run everything by them and then run it by the court. The law is the law. Regardless of how Mr. Yalman feels about me, the law is the law. This isn't anything personal. We're advocating. He says Mr. Faust did it. I say Mr. Faust is innocent. This should not be admitted without laying a proper foundation. It is admitted without a foundation. He's saying, hey, Your Honor, we're going to go through the questioning while we're showing the jury what the exhibit is. That's not the law, Your Honor. The law says that before they can present demonstrative evidence, they have to lay the proper foundation. That was not laid. The Honorable Court admitted it without even hearing us out on it, just denying our objection. So, Your Honor, Mr. Faust is not receiving his due process. process rights. I am requesting a mistrial.
Yes, sir. All right. So first, I just want to respond, Mr. Cruz, to your comment that the defense is hamstrung, that the state has free reign. It is unfortunate that you are, as an attorney in this case, responding to the court's rulings in that way. The court certainly endeavors in every way possible to make rulings according to law. And it is unfortunate that you feel otherwise. That being said, you have asked for a mistrial. I'm denying that motion. There are no grounds for mistrial whatsoever in this particular moment. This is a demonstrative aid. It has been admitted into evidence, but
This is a critical clarification. Demonstrative aids don't go back to the jury room. They're visual tools, not evidence you deliberate with. That's why the judge is denying the mistrial here. Legal takeaway. Judges have wide discretion on demonstratives, and appeals courts usually back them.
Demonstrative aids do not go back to the jury. The state is correct. They did provide you the opportunity to see that demonstrative aid. They did not have to do that, but they did. You are mischaracterizing the court's rulings, Mr. Cruz, in suggesting that this court is somehow forcing you to show the state your hand without making them do that. That doesn't fit any of the scenarios in this case so far. And that is a mischaracterization that is pretty frustrating for the court to hear. There are no grounds for a mistrial. The state has properly authenticated this particular aid, and the foundation has been laid. There has been no violation of 403. I find that this moment has not even suggested that 403 is even in jeopardy. And I'm making a finding again that the evidence is, at this point, not improper. This is a demonstrative aid, and I'm denying your motion. You may bring the jury out.
Yes, ma'am.
You all may be seated. Yes, sir.
Your Honor, I am again moving for a mistrial. We can't impeach witnesses. We can't argue consent. The state can present things that we can't present. We can't rebut allegations in their indictment. We are requesting a mistrial. This is not fair. This trial has been worse than practicing in communist Russia. He doesn't stand a chance in this courtroom, Your Honor. The witness.
Wow, that comparison right there. Saying this trial is worse than communist Russia, that's not just emotional. That's dangerous. When attorneys attack the fairness of the court itself, judges often respond fast and firm. Watch the temperature shift.
He's made a prior statement. We played the recording for the court. The witness made a prior statement. He was wearing like an orange-colored shirt. Orange or red, something bright. That is a quote. We played the recording. The Honorable Court was able to hear that recording. Her testimony here today was that he was wearing a hoodie. This is important because the state wants to make all the people that were seen in the neighborhood Mr. Faust. The person that they brought, the first witness in for, said, oh, he had a jacket. So, of course, they want her to say, oh, he had on a hoodie. It's an inconsistent statement. We are handcuffed, Your Honor. We are asking for a mistrial in this case.
Thank you. Mr. Bolden, do you care to respond before I make a response?
Your Honor, Mr. Cruz has failed to make the proper foundation for a prior inconsistent statement. He has not asked the witness a question that the witness then denied. And so it's just not a proper foundation. So that's the basis of the state's objection. As to his motion, I think I have to make a response.
All right, thank you, Mr. Bolden. So, Mr. Cruz, the first thing I want to say, and we are outside the presence of the jury, is that it is unfortunate that your constant comments about the unfairness of this trial it's very unfortunate. It is outside the presence of the jury, but it is not appropriate to continually just argue to the court that things are unfair and that somehow the defense is handcuffed because of the court's rulings. As I stated before, the court endeavors in every respect to make rulings based on law. So that's the first thing. And, having a slight tantrum every time you get a ruling that you don't agree with is really not appropriate. And I'm going to ask you to consider that moving forward. The second thing is the state is correct, Mr. Cruz, in terms of the procedure to request to admit an inconsistent statement, and you have not done it properly. I will say, for the record, in this particular moment, that your question was not the appropriate question to ask to recognize an inconsistent statement. It was kind of a trick question of sorts. You asked her to describe that particular piece of clothing, and her response was, I would say it was a hoodie, as if there was sort of the question allowed this witness, at least in my impression, to sort of pick, was it sort of a shirt or was it a hoodie? And the testimony, as I heard it, was that she elected to sort of describe it.
Here's a legal nuance most viewers miss. To impeach a witness with a prior inconsistent statement, you can't be vague. You have to lock the witness into the exact prior words. The judge is basically saying, you left the door open and the witness walked through it. Do you think the judge is being strict or correct?
Hoodie. If you would like to make an argument that in and of itself is what the law says is an inconsistent statement under the evidence code, then I will hear it. But if not, I'm going to sustain the objection and ask you to move on, sir. You may be heard, yes. And then I'll talk about the mistrial in just a moment, but go ahead.
The federal court has a statute. But if you have it, really.
Well, I mean, Mr. Cruz, I'm not going to advise you on the law. I think you need to be here prepared to argue it.
OCGA. The statute is OCGA 24-6-613. Prior statement of witness is the title of that section. Under subsection 8, the law provides in examining a witness concerning a prior statement made by the witness, whether written or not, the statement need not be shown nor its contents disclosed to the witness at the time. Provided, however, upon request, the same shall be shown or disclosed to opposing counsel. Your Honor, in this case, I went above and beyond. I actually chose to refresh her recollection as opposed to impeaching her when we were talking about her statement. She heard the entire statement. I told opposing counsel, this is what I had. They heard the entire statement. Subsection B provides, except as provided in Code Section 24-8-806, extrinsic evidence of a prior inconsistent statement by a witness shall not be admissible unless, first, the witness is first afforded an opportunity to explain or deny the prior inconsistent statement, which we did. I said, Your Honor, this is a quote. I read the statement as a quote. She said it was a hoodie. I confronted her with the statement, gave her opportunity. She still chose to say this was a hoodie. Second, and the opposite party is afforded an opportunity to interrogate the witness on the prior inconsistent statement. That the state will have opportunity to examine her on the prior inconsistent statement.
Mr. Cruz, what is the statement you're saying is inconsistent with this witness's testimony? I think that's part of what the state was endeavoring to argue. So what is it?
So the written question that I asked, the individual that she saw walking, did she state he was wearing like an orange colored shirt? She said that he was wearing a hoodie.
Well, that wasn't the question you asked, Mr. Cruz. The question you asked gave her an option to sort of describe what she meant. and you said something to the effect of, was it like a hoodie or a shirt? And she opined it was like, I'll say a hoodie. I'm not sure that's an inconsistent statement, but I will let you question this witness again with specific questions if you would like to elicit the proper information for the court. I will let you question her right now out of the presence of the jury, and we can go from there.
Sure. In your prior statement in law enforcement, did you state he was wearing like an orange colored shirt, orange or red, something bright?
Yes.
We can bring the jury back in. That's it.
All right, and Mr. Cruz, I want to comment on your motion for mistrial. I'm going to deny that motion. The granting of a mistrial by the court is a very, of course, as you are well aware, extreme option. And it is done in very limited circumstances where the matters that have been presented in court are of such a prejudicial matter, such a prejudicial level that the defendant cannot receive a fair trial. And with regard to your motion, you have not sufficiently shown this court that that exists. And so I'm going to deny your motion. All right. Can you bring the jury in, please? Thank you. Holden, you have an objection?
Your Honor, Mr. Yalamanchili and I talked in anticipation of us getting to this point over the weekend. Since I had made opening statement,
I'll pull that microphone towards you. Thank you.
that I would object since I had made the opening statement, since Mr. Yalamanchili had made the 412 arguments in the past that he would handle.
All right. Thank you. Go ahead, sir.
Your Honor, this court's aware, this state's aware. If Mr. Cruz wasn't aware before we started all the pretrial motions in this case, he ought to be aware now. Making reference, whether it's a statement made by some other witness, whether it's a direct examination, cross-examination, or any other method to a relationship between Miss Baker and anyone else that was not noticed by the defense as a 412 act is prohibited by 244412. I'm not sure how much clearer the statutory language could be. Not sure how much clearer the court could possibly have been in its instructions. But whether it's Mr. Cruz making reference to a statement that some witness made during an interview with law enforcement, or whether it's Mr. Cruz eliciting the testimony on direct examination or cross-examination, it is all prohibited by the rule, which Mr. Cruz has violated now for the second time in his opening statement. It does not matter. It does not matter one bit whether or not Chris Melton said that in an interview to law enforcement for the analysis of whether or not it is admissible and the methods that must be adhered to if the defense intends to admit it in any way, shape, or form, Judge. And so this is the second time before we've called the first witness to the witness stand that Mr. Cruz has violated 412 in what seems at this point to be an intentional pattern to try to work his way around the laws and rules of the state of Georgia as it relates to admissible evidence in cases involving allegations of rape and aggravated sodomy, Your Honor. So again, at this point, I don't know what the remedy is that the court wants to enact, but obviously telling Mr. Cruz not to do it isn't effective because he's not listening and he's not following the court's orders.
Cruz. Any response?
Either in this case, is that Chris Melton committed this crime. Chris Melton's statement, he's confronting DNA that he already knew was present that she was with someone else had. It has nothing to do with us trying to figure out. That statement is for the sole purpose of showing his consciousness guilt. He knew this information in 2004. He showed the exact same information in 2004. And his response isn't, oh my girlfriend, I can't believe it's happening, you guys better conquer. His response is just simply saying, oh, bro, let's do it. He's just There's no evidence that I intend to present that Chris Melton knows about this dangerous sexual history. There's nothing I can intimate that this danger knows, that Mr. Melton knows about this dangerous sexual history. The purpose of that statement has nothing to do with her character, or her sexual character. The purpose of that statement is to show Chris Melton's response. When he's presented with some evidence, he gives a response that's inconsistent with the person that is innocent. So this isn't a 412. I understand the state may not like what I present, but that does not mean I have to prove every single statement I have to them so they can prepare their case. This is open statement. I am, I respect the right of anything. I've told you that multiple times. This is not a 412 argument. This is Chris Melton who knows nothing about this dangerous sexual history, being confronted with a piece of evidence and making a statement that shows consciousness of guilt in our. This has nothing to do with sex.
Right, thank you. As this court has stated multiple times, this is the second time today, multiple times during hearings, that there is a process that must be adhered to in order to get the appropriate permission from the court to introduce statements, evidence that another party objects to. In this particular case, it is a 412 motion. We have talked about this over and over again. What I have said over and over again is that the defense has failed to file a motion under 412. The state did. The defense has failed to file a motion, and I've said many times that if the defense files a 412 motion, even though it's not timely, the court will consider it. There has been no motion filed. Mr. Cruz, you've been made aware many times that you are not to bring in this kind of statement. I mean, I realize I have said several times today that opening and closing arguments of the attorneys and arguments are not evidence, and I'm going to say it again when the jury comes out. But you've been told many times that in order to, I'm talking now, Mr. Cruz, thank you. You have been told many times that in order to present statements like that.
And there it is, contempt of court. A $1,000 fine payable by 9 a.m. That's not about money. That's a warning shot. The judge is saying, you don't get to argue around my rulings. Final question. Did defense counsel cross the line, or did the court overreact?
Ask for the admissibility of evidence like that, you have to file the proper motion. And the court may consider it, even though it's not timely. As I just stated 10 minutes ago, I do find your statements to the jury to be avenues to circumvent 412. And it is not appropriate. I'm finding you in contempt of court. You have had the opportunity to explain yourself, and I'm fining you $1,000. And you are to present that $1,000 tomorrow morning by 9 a.m. Put it into the registry of the court. And that is my sanction for continuing to not abide by this court's orders. I don't know how many times we're going to have this, but it really can't happen again. $1,000 tomorrow morning by 9 o'clock.